Unregistered agreement for sale of immovable property be used as evidence in the suit for specific performance. This is the topic. The Kerala High Court says yes. In this detailed legal analysis, we explore the landmark ruling in Shaju versus Victory Granite Bricks Pvt Limited. We dissect the impact of Section 17, Section 49 of Registration Act 1908 and explain why an unregistered sale agreement may still hold legal value in the court. Hello everyone, welcome back to today's Legal Insights. We have two channels, RR Corporate and RR Legal Talks. Can an unregistered sale agreement be used in a suit for specific performance? This is what today's topic. A recent ruling by Kerala High Court in case of Shaju versus Victory Granite Bricks Pvt Limited and another. The court held that unregistered sale agreements can still be admissible as evidence in specific performance suits. We'll see the background of the case. The dispute arose from an agreement to sell in immovable property. So the key facts, the agreement executed in 2014 and plaintiff claimed full compliance with sale terms, including full payment. Defendant denied validity, enforceability, and agreed price 9,000 per cent, 9,000, alleging 61,000% instead. This is the key facts. These are the key facts. So key documents in question is Exhibit A to an unregistered sale agreement. This document is in question. So the plaintiff filed a suit for specific performance under the Indian Contract Act 1872. So the defendant opposed, arguing the document was inadmissible for lack of registration. This is the crux. So the legal question before the court is, can an unregistered sale agreement, which is compulsorily registrable under Section 17, 1F of the Registration Act, be used as evidence in a suit for specific performance? This is the legal question. So this led the Kerala High Court to analyze the interplay between Section 17 and Section 49 of the Registration Act 1908 and judicial precedents, including Supreme Court's interpretation. So if you see section-wise analysis, Section 17 of the Registration Act 1908, Section 17 1F inserted by 2013 amendment requires compulsory registration of agreement for sale of immovable property for consideration. Implication: unregistered agreement may be invalid for the purpose of creating or transferring rights in immovable property. This is what Section 17. Section 49 of the Registration Act. So the key provision prohibits the use of unregistered document affecting the immovable property for any purpose unless registered. So, but there is a proviso to Section 49, which is crucial for us. What is that proviso to Section 49 of the Registration Act? So, this proviso allows unregistered document to be received as evidence of the contract in suit for specific performance or for providing collateral interaction. So, this proviso allows unregistered documents to be received as evidence of contract in a suit for specific performance or for providing collateral transactions. So Kerala High Court interpretation, even after the insertion of Section 17 1F, the proviso under Section 49 remains intact. So hence the intent of the legislature was not to bar unregistered agreements for all the purposes. So hence the intent of legislature was not to bar unregistered agreements for all the purposes. So court's observation and ruling. The key observations we see, the amendment to Section 17 does not override the saving clause in Section 49's proviso. So the court reaffirmed the ruling in R. Hemalata versus Kasturi by Supreme Court, which upheld similar reasoning. So the purpose of the agreement, conduct of the parties plays a crucial role. So the final decision, Exhibit A2 is admissible to provide a contract, to prove a contract. So the unregistered sale deed in unregistered agreement. So Exhibit A2 is admissible. So the plaintiff had paid full consideration, bought stamp paper, complied with his part of the compromise. So the defendant's counterclaim the defendant counterclaim of trespass was rejected. So this is it was upheld. Unregistered sale agreements are admissible in a specific performance suit, and refusing relief would amount to injustice when one party has fulfilled their obligations. So legal implications and takeaways, if you see the practical point for legal practitioners, always advise registration of agreements, but in suits for specific performance, an unregistered agreement may still be valid. Maintain evidence of consideration, compliance, and conduct. Use the proviso to section 49 when facing objections on non-registration. For litigants and real estate buyers, never rely entirely on unregistered documents. Always prefer registration. But if you are facing, if you are already in dispute, this ruling is a ray of hope. So case summary, case name Shaju versus Victory Granite Bricks Pvt Limited, and another citation Kerala High Court RFA number 593/2017 and 75 of 2019. The decision unregistered agreement held admissible specific performance granted. So the conclusion and closing. Thanks for watching. This ruling reaffirms the principle that courts will prioritize equity and contractual performance even in the absence of registration, provided there is a sufficient proof. So don't forget to like, share, and subscribe. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of the latest updates on corporate laws and NCLT matters and public issues. Thank you. We have two channels, RR Corporates and other channel, RR Legal Talks. Please do subscribe. Thank you.